Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And I thought I'd make a video about an issue that we're running into lately. It might just be coincidence, but I think it actually is something that is out there for a lot of people, which is that they've got old estate plans. They've got estate plans that are sometimes 20. We've got one right now that came in that is actually more than 30 years old, and it's still in effect. It is still the trust. The will that they did at that time is the will. And so, some of these documents, the will especially, they're in effect until you actually revoke them. So you can actually end up with some very old documents. But we get a lot of people in here who have kids, who are in their 20s or even older, and the parents say, yeah, we did a will, and it was, appointed guardians for them when they were under 5 years old. So very old documents. And you might think, well, documents, at one point they made sense and probably isn't too far out of line with what I'd want anyway. And it's okay that they're a little bit old. At least I did it at one point. So I'll get around to getting it up to date at some point. But we're really running into some very big problems that are because the documents are old. And there's a few reasons for that. Obviously, one is that circumstances change within families, right? There might be more members, there might be fewer members, people might have gotten married, people might have gotten divorced, there can be births, there can be deaths. So just having a document that was designed for a totally different family structure obviously can have some bad effects if people are accidentally getting left out or getting too much or whatever else. But people really underestimate how often the law changes, especially around taxes. I mean, as you probably are aware, every time we get a new administration in here and the presidency, approach to taxes can change quite dramatically. And then retirement accounts. That is usually people's first or second biggest asset, depending on how much equity they have in their home. And so it is really important. And just in the last, 5 years, less than that even, retirement accounts are taxed. But even beyond that, there's the estate tax. So we get a lot of people in here asking, well, I really want to avoid the estate tax. Well, right now, the estate tax really doesn't affect very many people, right? You have to have, as I'm recording this video, almost $13 million to even have an estate tax issue. Married couples can combine, so they get almost $26 million to give away before they have an estate tax issue. Well, the problem with those older plans that I mentioned, some going back 20 or 30 years, is back then, everyone had an estate tax problem. Back in 2000, you could only give away $600,000 before you started having an estate tax problem. So obviously, even adjusting for inflation, a lot more people had problems at $600,000 than they do at $13 million. So there's just a lot of planning done around avoiding estate tax back then, which is kind of irrelevant now. And if it was just irrelevant, that would be great. But people did things like putting stuff in a trust for kids or transferring assets into other people's names or putting one spouse on one thing and one spouse on the other thing, doing all kinds of things that would have other consequences, but it was worth it back then because the estate tax took such a bite. I think it was, $600,000, and then everything above that was taxed at 55% or something like that. And then you had state taxes too. It could really get oppressive, right? So it was worth it to go through some hassle, potentially have probates going on for spouses and all kinds of stuff. It just doesn't make any sense anymore because we don't have that issue. So we've really seen some stuff where it has really caused some problems in families that have stepkids, or again, just, kids that are now 20 or 30 years older than they were when we did the plan last time. So if you have an old plan in place, do not assume that it actually is okay and it's just, you'll get around to it when you get around to it. It might cause problems that you would not have if you had no plan at all, because at least with no plan at all, you'd be in an intestate estate and you go by the state laws. Well, those are not totally out of whack with where estate taxes are and the other issues that I just discussed. So in some circumstances, I would tell people, just get rid of that plan. And we've seen that where people will actually come in and will actually just, yes, we can get this plan done within maybe the next few weeks or so. In the meantime, let's revoke the plan that you currently have. So you have no plan and we're just going to run the risk and hope, we're going to get through those next few weeks and you'll be fine, which usually happens. But yeah, there can be circumstances where no plan is better than your old plan. And so just be aware of that. And if you have a plan that is, more than 5 years old, you should definitely look at it. If it's more than 10 years old, the chances that there are no updates needed is very minimal. And if we get much further than that, it probably is getting increasingly urgent that you really look at it and start coming up with a plan that makes more sense for today's laws, your family today, and the dynamics that you're dealing with now. So hope that helps and hope that that kind of lights a fire under you if you've been kind of thinking, I got to get back to that and think about that again. So again, I'm Dan McKenzie with the McKenzie Law Firm. We're in Denver, Colorado. Our phone number is 303-578-2745. You can find us at themckenziefirm.com. If we could be helpful helping you update a plan, we would be happy to have that conversation. So feel free to contact us. Hope this was helpful. Thanks.